everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. Let's see which articles we will be discussing today. So the first article is from The Hindu, which is titled as Smothering the Housing Rights of the Urban Poor. Basically, this article has come in the light of the recent Supreme Court judgment wherein thousands of people who were living into some slums in the city of Delhi have been ordered to evict within 3 months. So the pros and cons of this and the backing of constitutional things in this case has been discussed. Second, Better Late, which is from the Indian Express, talks about the recent vaccine that we were about to have from AstraZeneca, which is a huge giant, which is a medical giant, which is working in Britain. And it was working along with the Oxford University trying to develop a new vaccine for the COVID-19 treatment. But now it has been halted. So why has it been halted, and why is it good to at least be late then producing something wrong would be discussed in here. And thirdly, the News and Flash column, wherein we'll be discussing the crisp and pointer news, which are important specifically for a prelims exam. Let's have a look at the LawSikho courses that we have for you. So we would like to bring to your notice the lot of the courses, which is the Judiciary Test Prep course. So if all of you are preparing for judicial services, you can definitely enroll yourself for this course. The link is there in the description box, and you can also download free study material from the landing page. We have various other courses as well, which can be looked at the LawSikho webpage. Then let's see what is the multiple choice question for the day. Which of the following are best performers in State Startup Rankings 2019? First, Gujarat and Andaman and Nicobar Islands. Second, Madhya Pradesh and Delhi. Third, UP, that is Uttar Pradesh and Chandigarh. Or fourth, Tamil Nadu and Puducherry. So if you know the answer to this question, do jot it down in the comment section below. So this is the descriptive question for the day. Right to shelter is recognized as a fundamental right, but in the recent case of MC Mehta versus Union of India Supreme Court 2020, please mind this is the very recent case, the order for eviction of slum dwellers would set a precedent and may impact negatively. Discuss. So once we have discussed today's article at length, we are sure that you will be able to understand the context of this question. The answer must be written within a word limit of 250 to maximum 300 words. You may also jot it down in the comment section below. With this, let's quickly start with the discussion of the first article for the day, which talks about the housing right of the urban poor. So first thing that needs to be kept in mind is that we are talking about the poor people, specifically who dwell in the urban areas and in areas that we commonly call as the slums. So this entire article is mostly, centered towards the urban poor. Recently, the Supreme Court in the case of MC Mehta versus Union of India ordered the removal of around 48,000 slum dwellings alongside the 140-kilometer long railway track in Delhi within 3 months. Now, since it's been months now that we have traveled to places, but if any one of you would have traveled to Delhi through any rail route, you must have noticed that when we are about to reach Delhi, then there is a huge cluster of slums that you can see mostly on both the sides of the railway tracks. So just like that, almost at a length of 140-kilometer long railway track, there is a huge cluster of slum dwellings over there. And the Supreme Court has ordered for the removal of approximately 48,000 of these slum dwellings, that too in a period of just within 3 months. Now, why at all we are discussing this in this article today? There are a lot of discrepancies related to this order given by the Supreme Court. Firstly, in the time of this COVID-19 pandemic, when the already stable people have been hit badly with the economic crunch, just imagine the situation of these urban poor who have lost their employment, have lost their jobs, and also do not have any good sources of income and health as well. In such a scenario, if we would like to move them from this place to somewhere else, and that too is not decided as to what are the relief benefits that would be given to them, we can imagine that what kind of a chaos that may be created. Secondly, the Supreme Court has just ordered this within 3 months, the removal of these slums within a period of 3 months, but no as such significant, compensation has been granted to these people. Let's see in detail as to what is the order basically. The Supreme Court was hearing the matter regarding pollution in Delhi in response to a report by Environment Pollution Authority of NCT, which is a National Capital Territory. So basically, as we know that pollution, all kinds of pollutions, now be it air pollution, soil pollution, water pollution, noise pollution, Delhi, being the national capital, is one of the worst hit cities and the worst or the most polluted cities in the world as well. So the Supreme Court was hearing a matter regarding the pollution, and in lieu of that, it came across the idea of actually this issue of having so many slum dwellings along the railway tracks. And the Supreme Court, in some other manner, it construed that these slum dwellings are also a big source of garbage and big source of pollution which needs to be removed. But the very thing in this entire order that has actually brought the concentration of various people, activists, and also various advocates to the question is that along with the order of removal, the court also directed the following, which is in huge controversy currently. Firstly, that no court shall grant any stay with respect to removal. As we know, that interim stay is many times provided on the proper implementation of something if the court believes that something else also needs to be brought into the eyes of court, and that is why some action is stayed from being taken. But the Supreme Court has ordered that no any court shall grant any stay with respect to the removal of these slums, and if it would be granted, it would be ineffective in nature. And secondly, no interference, whether political or otherwise, should be there. So in a way, the stance or the idea with which the Supreme Court has given this judgment is seeming to be too absolute in nature. And as we know, even under the Constitution of India, no provision is absolute. We always have some of the other leeway, or what we call as the reasonable reasonings, restrictions, whatever you call. But in this order that has been given by the Supreme Court, it seems too absolute in nature, because the Supreme Court has made it so watertight that no other court also shall be given any power to stay the decision. And if it tries to do this, it will be ineffective in nature. Let's see that what are the precedents related to the matter, as to related to the right to livelihood or related to the place of residence or something like that. Firstly, the very, very famous case, which is called as the Olga Tellis case, Olga Tellis others versus Bombay Municipal Corporation, which is a case of 1985 and directly related to Article 21, wherein the 5-judge bench of Supreme Court held that right to life under Article 21 of the Constitution of India includes the right to livelihood. So in a way, any individual is able or would be able to enjoy his right to life only when he has right to livelihood. And for these people who are living in these slums, maybe they are working through these slums, or these are actually the only thing that they can afford and cannot really afford any other kind of accommodation. So in a way, it is a part of their livelihood, which ultimately is a part of their right to life, which is a fundamental right under Article 21. And secondly, no eviction shall take place without notice and hearing those affected. Now, another controversy that has been rising against this very judgment of MC Mehta of 2020 against the Supreme Court is that the principle of natural justice have not been followed in this case. Now, we know the principle of natural justice, which talks about audi alteram partem, which means that no judgment would come unless the court has heard the stance of the other party. But unlike in this case, the stance or contentions or what the slum dwellers, who actually would be the most affected people through this judgment, their stance has not been put at all. So in a way, we can say that this has been more of a one-sided decision, and the right to hear, which was a natural justice right to all these people, has been violated. Then secondly, in the case of Chameli Singh versus State of UP of 1995 Supreme Court, it was held that right to shelter is a component component of right to life under Article 21 and freedom of movement under Article 19(1)(e). So again, it was held that right to shelter, again, in the earlier case, it was right to livelihood, and directly now in Chameli Singh case, it is right to shelter is a very important component of right to life as well as right to freedom of movement under Article 19(1)(e). And then in the case of Sudama Singh in 2010 of Delhi High Court, it was held that prior to any eviction, basically eviction means the activity of taking someone out from any place where they are currently residing. So in this situation, the slum dwellers would be evicted. The court has ordered their eviction or to take them out from the slum dwelling. So prior to any eviction, a survey must be conducted, which in this case was not conducted at all. And those evicted should have a right to meaningful engagement with the relocation plans. So once it says that firstly the survey should be conducted, and whatever plan the government is now making to relocate these people who are being affected or who are being evicted in this case, they must be a very important part of the decision making when it comes to meaningful engagement and to relocate these people for new plans or areas. Then it formed the basis for Delhi Slum and Rehabilitation and Relocation Policy 2015. Then it was again reiterated in the case of Ajay Makan and others versus Union of India and others. Basically, all these guidelines or all these precedents which were actually held or which actually came into picture one by one have been completely overlooked by the Supreme Court in this judgment. And this Ajay Makan case actually led to the framing of draft protocol of 2015 policy, which in this case has not been taken care of. So this definitely is a human rights issue as well as an issue that has violated not only the natural justice but also the fundamental rights of these slum dwellers. And definitely the court should be lenient on this part, and the government should be taking effective steps, firstly, to ensure that the fundamental rights and human rights of these slum dwellers are not violated, firstly. And if at all, in the name of pollution or any other reasoning, if these slums have to be relocated or have to be upgraded to some other area, the people should be made, or the affected people should be made a part of the decision making and should be given to say reasonable compensation for the things. So eviction data amidst the COVID-19 pandemic has brought in that over 20,000 people were displaced in 45 incidents of forced evictions between March 25 and July 23. And then over the past 3 years, over 5 lakh people have been evicted, especially for various city beautification projects. And this is a very ironical thing that at one place we talk about beautifying the cities to make them more, beautiful, more appealing, attractive, cleaner, pollution-free, etc. But then again, we should not forget that these people, who are also very much the citizens of India, they shouldn't be just, moved from one place to another, and we should not really think them to be trash and something against the beauty of the city. We must actually invest more and more in these people, that actually they also can become the asset for the nation, instead of, disregarding or, demeaning these people. So that is something the government and also we being the responsible citizens should understand. Now with this, let's discuss the second article for the day, which talks about suspension of Oxford's trials. Now recently, AstraZeneca, as we already discussed, that it is a huge medical giant, which actually has, in India, we have various institutes, various bodies that very actively make drugs and the other kinds of medicines. So AstraZeneca is one in the UK as well. So it has announced halting or pausing, or it has brought to a halt its ongoing clinical trials for COVID-19 vaccine after one of the volunteers on whom actually this drug which was being produced, this vaccine was tested, developed inflammation in her spinal cord. So basically, as we know, in our previous sessions, we have also discussed that there are basically 3 stages of trial, wherein first, second and third stages are followed, and any vaccine that actually passes all the 3 trial stages successfully is only declared to be a successful vaccine, and only then it can be circulated to the common people. And for the testing, various volunteers actually, they come up from different age groups, different say morbidities or something. They have different kinds of volunteers, they actually are chosen, and then these drugs are tried on them. In the similar process, when this AstraZeneca and Oxford vaccine drug or the vaccine was being tried on one of the volunteers, she has actually developed inflammation in her spinal cord. So this has been a major inflammation, and that is why the entire testing or the release of this drug or the vaccine has been paused for now. So the Indian collaborator, which is Serum Institute of India, and it is important for us to know that Serum Institute of India is also one of the candidates that is running one of the vaccines for COVID-19. So maybe we might be able to have a successful one from India, has also put the trials on hold. So what have been the past instances of such things? So as we know, in 2014, Ebola virus was very much prevalent. So the works on Ebola vaccine was temporarily stopped after some volunteers suffered arthritis. So it is not something that it has happened for the first time, but yes, it is taken of high importance that if any of the volunteers develops any medical issue due to the governance of that vaccine, so it is completely halted for that time, and it is checked thoroughly for any other discrepancies. Now let's see that what could be the implications of this. Firstly, no substantial reason to abandon the trials. Unlike phase 1 and 2, phase 3 involves volunteers who may have underlying medical condition or above 70 years of age. Possible that the volunteer's illness has no connection with the vaccine. So in a way, this halting or this pausing has been done as a precautionary measure or a preventive measure so that no any discrepancy is left in the vaccine. But yes, there is always a chance that any kind of inflammation or any kind of reaction that a volunteer has seen due to any vaccine might not really be due to that vaccine and maybe due to some other personal medical reasons as well. Like for example, in this case, the inflammation in the spinal cord of this woman or this volunteer may be due to some other personal medical reason, due to which she might have been already suffering, and not really due to the AstraZeneca vaccine. But of course, being responsible, producers of the vaccine, it is very much desirable that they actually pause this situation right now and they understand as to what is the real reason behind the inflammation or behind the any kind of reaction that is going on. So the halt should be seen as a part of rigorous scrutiny. So this is something which we as common people should not see it as a failure on the part of the vaccine developers. Rather, we should be delighted with the fact that they are taking due precautions and they are being very careful about the quality of the vaccine that is being developed. So this was all for the major articles for the day. Let's see that what do we have for news in flash. Firstly, new grievance redressal portal in Jammu and Kashmir. Now, since we know that we are slowly trying to develop better administration in Jammu and Kashmir Union Territory. So the Lieutenant Governor of Jammu and Kashmir, Manoj Sinha, he's also been recently appointed as the Lieutenant Governor. So this also should be kept in mind. Launched the JNK, which is Jammu and Kashmir Integrated Grievance Redressal and Monitoring System, which is known as JKIGRAMS, on a pilot basis. Always remember that whenever we have this term pilot basis, so it means it is for some ad hoc purpose or some experimental basis. That means the success rate of this will be analyzed for a period of time, and if it is successful, then it would be applied for a longer period of time. So it is done on a pilot basis for Jammu, Srinagar and Reasi districts, to be extended to the other districts by October 2, 2020. So this will replace the current portal launched in 2018 and will make Jammu and Kashmir the first union territory to be linked with central government systems. So this is an important step that has been taken for Jammu and Kashmir. Secondly, Stress for People Challenge. The Union Housing and Urban Affairs Ministry launched the initiative to make cities more pedestrian friendly, provide safer means of transport with social distancing. So basically, Streets for People is for providing easier movement to the pedestrians. Like in Delhi also, you must have seen that there are huge crossover bridges that are available on very wide roads, so that the pedestrians can easily and safely cross the roads. And also the footpaths are also available that are grilled from the side so that they can move safely. So almost in the similar line, this has also been brought into action. So the Climate Smart Cities Assessment Framework 2.0 was also launched with an aim to give cities a roadmap for tackling climate change. And thirdly, State Startup Ranking Report 2019, second edition of it. So the list was topped by Gujarat in the Startup Ranking 2019 for the second time, and it was followed by Karnataka and Kerala. So these are as states. So for the states, as Karnataka and Kerala have topped it, and for union territories, Andaman and Nicobar Islands have topped it, followed by Chandigarh. So this is also an important stat. A very potential prelims question can also come through this. So yes, this was all for today. We hope it was a good and informative session for you all. Stay tuned with LawSikho for such more sessions to come. Thank you so much.